With us now is former prosecutor Jeremy Saland for more on this. All right, let's talk about jury instructions because I think that's really interesting in a second. But first, just your initial reaction to all indications now pointing to Hunter Biden not taking the stand.
I mean, shock said nobody who's an attorney, and for that matter, probably many people in the public. You want to testify because you think that's the best evidence, and it very well may be, but there's so much impeachment material, there's so many things to confront him on, not just what other people have said, but his own words, his own actions. Evidence is really strong against him, so it's a smart move, but I'm sure he wants to say, I wasn't using drugs then, I was not addicted.
That's what I was going to ask you. What risk outweighed the benefit here in the end, do you think, with regard to him taking the stand?
Well, Lowell is trying to make the argument we just heard that at that moment he was not addicted and he didn't believe he was addicted and he was clean during that time, and you heard from his daughter that he was doing well even though she was impeached as well.
Right.
But you know, if you get up there and all of a sudden you open that door and you're going to be asked, wasn't it true you did this, and then there's this, and then there's the image, and there's the book, and there's the residue from the cocaine and the crack cocaine, and there's a crack pipe, and there's so much that they're going to build and build and build, and before you know it, your credibility is shot. And right now, if we believe what we have read, that you had one juror, for example, who was crying and in tears, there's a real opportunity potentially at a nullification or maybe hanging someone. You get in there and you lie, it's not good.
It's a great point. So let's now get into this discussion that is happening, kind of argument in court right now, regarding jury instructions. We know, especially from very recent past, jury instructions, the language of a jury instruction is so important to how things proceed when they go behind closed doors. Abby Lowell, Hunter's attorney, agreeing to allow the judge to give an instruction to the jury that they shouldn't hold it against him, that he did not testify in that case. But then this discussion about what additional language or not can be, will be added with regard to the instructions. Why does this matter so much?
Well, it shouldn't be just shouldn't, it should be can't. He has a right to testify. He doesn't have to testify. And you should not take an assumption or presumption one way or another. That's so critical because you cannot use your lack of words against you. That's not fair, and no one should be judged that way. And the law and the Constitution says that. So that's number one. Number two, I almost forgot the question, but...
with regard to, they're fighting now over what additional language in jury instructions. With regard, as Evan says, the judge has already said that the word knowing is going to be in the instruction, but Abby Lowell is pushing for there to be more.
Because Lowell is hanging his hat that at the time when he meaning Hunter Biden, was filling out that form, he wasn't knowingly an addict, he wasn't knowingly an abuser of drugs, and if he was clean during that time, and you've heard evidence from moments before and maybe moments after, but during that moment in time, he was sober and he knew and believed he was, and didn't believe he was violating the law, that is so critical. That goes to the heart of their case. That is really, the depth of their case, believe me when I say he did not know.
This just made me wonder, when it comes to closing arguments, you can lean on a lot in terms of thematically in your closing argument, but for the defense, do you lean on the lack of pinpointing him being on drugs at that moment with the jury, or do you lean on more of the emotion that we have seen come out and the relatability?
They're not mutually exclusive. You can absolutely, and you should lean on the fact that the evidence corroborates that he was doing drugs or was addicted potentially. And that term is very vague, but he was addicted to drugs at time A, B, and we'll say that the gun possession and purchase was time C, and maybe at time D, but at time C, at that moment he wasn't. And even if you may believe he was, this is a common problem that we all have to deal with in families and friends and people we love. Addiction is scary and frightening, and you lean on that too, to paint that whole picture.
What you're kind of pointing to this, the likelihood of a hung jury in this case is what, do you think?
You know, I can't give you certainly a number. It doesn't really work that way. But it's much, you know, when people were talking about potentially the hung jury in the Trump case, there was no emotional component. There may have been a political component there, but there was no emotional. It didn't, you know, tug at your heartstring and say, I know somebody who falsified records, and they were really, you know, it was really sad and terrible. You know, look, as I clutch my chest here. But you can say, I know somebody who had a horrible addiction, and they're good people and a good person, and it's disease, and they, you know, made really bad mistakes. But should they be held accountable in perpetuity for it? No. And that's the kind of thing that you would pull onto.
It's really interesting. I'm really curious as to how this all plays out now. It's great to see you, Jeremy. Thank you so much.